Alex here with a legal nuts and bolts video on requests for the production of documents and things. This is the third video in a four-part series on discovery tools. I just wanted to let people know what these various different discovery tools were and how you could use them yourself, and also how to respond to them, because if you're representing yourself and the other side has an attorney, you may end up getting some of these, and there are some consequences for not responding to them. So anyway, if you get a chance, please watch my earlier video on discovery. It'll give you a more overarching big picture view as to what the discovery process is, and this won't seem as just isolated as if you just watch this video out of the blue. So the last two videos I covered requests for admissions and interrogatories. Those are two different documents that you can send your opponent to force them to respond to and figure out which direction you may want to go to in a case based on those responses. The request for production of documents and things is very similarly going to help you decide how strong your case is. It may be, you know what, maybe it's not similar, because unlike requests for admissions and interrogatories, you're not really asking for responses from your opponent, you're asking for documentation from your opponent. So it is more of an issue as to how strong is your case based on the documents that you can force them to produce to you. So with the request for production of documents, you can ask for documents. You can list, I think it's 40. I mentioned in request for admissions some of the nuances as to how the default number of requests works based on what court you're in, or if it's even the same. It may be the same in your state, or even in Nevada. I haven't looked into it very carefully. I just know that you need to look into it, or you won't know exactly how many of these you're allowed to send out. But anyway, with the request for production of documents, you provide a list. And in that list, it's going to say the documentation that you want from your opponent, and they have to basically get that documentation and turn it over to you. At that point, you can look through it and see if it strengthens an issue or weakens you. You know, it's going to reveal to you whether, this is what I thought I was going to get, that's good, or this is not good, I thought that I was going to get this documentation, this weakens my case. A lot of times people will play games with these requests for production of documents because they'll want to win their lawsuit, and dealing with people who are playing games with the request for production or flat out destroying documentation, all of that stuff is outside of the scope of this video. Dealing with those types of issues can be so complex and requires a lot of research. There's a lot of case law around how to deal with opponents who are not producing documents they've been compelled to produce, or even destroying them. There are serious consequences of doing that, but I'm not going to cover it in this video. I just want you to know that if you get a request for production of documents, you have to produce those documents. Unless you have some kind of way of arguing privilege, or that they're irrelevant, or that they're phishing or whatever. You can, of course, deal with, you could object to things. But I'm just saying, if you have no objections, you have to produce those documents that were requested. And, of course, you can use this tool too. You can send this tool to your opponent, and if they have those documents, they need to produce them to you. Same thing, if you ask for things that are privileged, if you ask for things that are irrelevant, they're going to just say no, and they're going to put an objection in their response. And, of course, if you want to fight that, you can go to the court, get the court to determine whether or not they have to produce that stuff. I wanted to add one little thing in here. Request for production of documents only goes to your opponent. They have to be a party to the case. If they are not a party to the case and you want documents produced from them, so we're talking somebody who hasn't been sued, they're not in the lawsuit, then you have to use a subpoena or a subpoena ducis tecum, and those are handled in a separate video. I know I have a video on subpoenas. I think that covers subpoenas ducis tecum as well. But anyway, yeah, if you're gonna ask for any kind of documentation or testimony from somebody who has not been sued and is not in your case, then you do not use this tool. You use the subpoena. So anyway, with that, I will end this video. If you have any questions, feel free to post it in the comments below, and I'll see you guys next time.